It's attorney Laura Sterling. Welcome to my live show. As you can see behind me, yes, here in the United States, if you're watching me from the United States, it is Thanksgiving, or it's going to be Thanksgiving in 2 days. That means Thursday. That's when we give thanks for everything that we have and everything that we hope to have. And we're thankful for our families and all the blessings that we've been given. And as you can see, that's what I'm saying here on my background. Now, as you know, I'm a big, Snoopy, Peanuts, all that kind of thing. My one dog is named Snoopy, like a little whoop with their Snoopy there. And as you know, or may not know, I got another dog, and guess what I named her? Lucy. That was by accident, purely by accident, I promise. But Lucy and Snoopy, I don't know how that happened. But anyway, I want to wish everybody here in the United States a safe, happy, healthy, fulfilling Thanksgiving. It's a time to sit down, be with family, enjoy, eat a lot, take a nap, watch basketball, football, whatever is your choice. So, hoping that everybody is safe. So, as you know, I've been doing my videos this month on criminal issues. And why? I mean, come on, it's Thanksgiving. Let's all be happy. But during the holidays, things tend to get a little bit out of hand sometimes. As you know, okay, Thanksgiving, you go over to cousin Joseph's house, right? And at cousin Joseph's house, all your other cousins are there, and your brothers and your sisters and your parents and your uncles and your aunts, and maybe they bring boyfriends, girlfriends, whatever. And then all of a sudden something happens. Somebody's got too much beer or too much wine or too much whiskey or whatever it may be. And then there's a little trouble, whether it be, a fight breaks out that you really didn't mean to, but because, the stress and you're drinking, or you drink and drive, God forbid, and, something happens criminally to you. So that's why at the end of the year, I know we're all joyous and we're all happy, but I like to look at the reality as a criminal defense attorney. I like to say, okay, I hope you're all safe. I hope you're doing everything you should. But in the event something happens, things happen. It just is the way it is. So that you have some knowledge that you can kind of work with in that situation. So that's why I'm here today. We might be a little shorter than the hour because I know that you're all busy. I wanted to get it done before Thanksgiving. I was looking at doing it next week, but I thought, you know what, then that's after Thanksgiving. So what good is it going to do? I want to do it before Thanksgiving. So I'm sure a lot of you are either at the grocery store. God bless you. I haven't set foot in the grocery store this week. I think I'll wait till after. So you're either at the grocery store fighting for that last can of candied yams or sweet potatoes, or like I was this afternoon at Honey Baked Ham. It's funny that I get the one to bring the ham when I don't eat meat, but it's okay. It's okay. I guess they figure that I'm not going to nibble on it. And by the time it gets there, that it's going to be half gone. But I picked up the Honey Baked Ham. It wasn't too bad today. I was quite impressed. They were pretty organized. When I walked in, I was hammered with questions by staff, and I was like, I don't know. I don't know. I don't know. I really didn't. I really truly didn't know. I'm like, I don't know. I have to look. They were asking me if it was prepaid or what. I don't know. I just have it on my phone. So I was able to pick up my ham, which, by the way, prices have gone up. It's been a few years since I got a ham. I think the last time I bought a ham, maybe 3 years ago, and it was like $90, maybe 80 something with a little coupon. This thing was $111. I'm like, this thing better be good. So, and I can't even taste test it. But at Honey Baked Ham, they did have, get this, an armed security guy outside. Apparently, it kind of gets unruly around this time of year at Honey Baked Ham. Who knew? Again, somebody might be at Honey Baked Ham getting their ham. I don't know, a fight ensues, I guess. Somebody was telling me about that happened one time. And you get arrested. So, these little criminal tidbits, I think, will help you in the long run and give you that information so that you say, okay, I need to deal with this. I remember that attorney Sterling, she said this. So you have a little tidbit in your head. And please, please, please feel free to throw up a question if you have one. I love your questions. Your questions, they're very thought-provoking, and they make me believe that you truly are thinking about things. So I appreciate that. Anyway, so I want you to kind of sit back, relax, knowing, like, again, we probably won't go the whole hour. I know you're all busy. If you're not at Honey Baked Ham at the grocery store or the liquor store, you may be home cooking. Family may be already arriving. The kids are out of school. You're trying to chase them around, get them fed, do whatever they're supposed to be doing. I know my son just arrived last night, so I'm pretty excited about that. So please sit back, take a breath, take a few moments for yourself, get yourself something to drink, a little nosh, a little popcorn or peanuts, although you're probably thinking, okay, I need to save those calories for the Thanksgiving Day meal. Good idea. Well, we're going to launch right into my live show. As you know, this is on Facebook and on YouTube. My mother kind of asked me in passing this morning, "Oh, where is your live?" I go, "Well, it's on Facebook and it's on YouTube and it's on at 2 o'clock Florida time, 1 o'clock your time, Mom." And she goes, "Oh, your father has a dentist appointment." I'm like, "Okay, well, alrighty." So I guess they're not watching me right now, but hopefully they'll never need this information. So it doesn't matter. So sit back, relax, take a deep breath. If you have a question, please throw it up. Have your little pen and paper, or however you take notes. I'm old fashioned. I do it by pen and paper. So, and let's proceed. So, what we're going to talk about today, criminal procedures. This is really a procedural matters here in Florida. Remember, each state has their own criminal procedures. So, this is Florida's. Remember, if you're watching me from California, Minnesota, New York, New Jersey, Connecticut, whatever, each state is different. So I'm just talking about Florida because that's the only state I'm licensed in. So if you have questions about what is in your state, please feel free to reach out to an attorney in your state, a criminal attorney in your state, to find out what exactly are the procedures in your state. So remember, I'm Florida. So let's start out. What is the number one thing in the United States, not even just Florida? This is standard throughout the United States because it was a United States Supreme Court ruling. Can I get it? Can I get it? Custody, interrogation. You're exactly right. The Mirandas. It was a case in the United States Supreme Court, Miranda versus the state of Arizona, where your Miranda rights, meaning you are, and there's two things that trigger those Miranda rights. So the first thing that triggers your Miranda rights is you're in custody. You are in custody of the police. So you have been arrested. You are unable to leave. If you're able to leave, you're not in custody. But what is a, how do I say this? What is a hands down issue of being in custody? Handcuffs, right? You're in handcuffs. You can't leave. You're in custody. You're in the custody, excuse me, of the police. You cannot leave. That's the one prong that triggers that Miranda warning. What's the second prong? The second prong is interrogation. What is interrogation? The police are asking you questions. They are questioning you regarding whatever it may be, whatever criminal charge it may be. So you see that now. I mean, everything is on TV now. Do you see it? Now they have interrogation. Is it Interrogation Raw? I think it's called, on one of those channels. I'm sorry, I'm addicted to all of those. I do watch it because I sit there and go, why are they answering these questions? Did they give the Mirandas? You know, I'm being what is that? Armchair quarterback. I'm saying, oh, they didn't give Miranda. Oh, they didn't do this. Oh, what is that? So you have to be in custody to trigger the Miranda rights, and you have to be in an interrogation. So if they take you into custody, but they don't ask you any questions, you don't answer any questions, then if they didn't give you your Miranda rights, no harm, no foul, right? There's no error there. But if they take you into custody, they handcuff you, they put you in the back of the squad car, and you're unable to leave, and they start asking you questions, then they need to go over the Mirandas. What are the Mirandas? Now, when I was in law school, I had a friend, Everett. Love you, Everett, if you're watching. He had a T-shirt with the Miranda rights on it. I always got a kick out of it. I thought that was the funniest thing. I go, oh, well, that's a good way to get them to read the Mirandas, to wear it on your shirt. So the Mirandas go over 5 rights that you're entitled to if you're number one in custody and you're being interrogated. You have the right to remain silent. You do not have to say anything. They question you. You can say, I'm invoking my Miranda rights. I'm invoking my right to remain silent. And that silence can't be used against you later on. You have the right to remain silent because anything you say in a custodial interrogation can be used against you if the Mirandas have been given properly. They can use whatever you say against you. So if they give you your Miranda rights and you answer their questions, yes, I did kill Johnny, or whatever it may be, and those Mirandas were given to you properly, they can use that statement against you. But if they take you into custody and they're questioning you and you're unable to leave and they don't give you your Mirandas and they ask you, did you kill Johnny? Yeah, I killed Johnny. Then that's motion to suppress by your criminal defense attorney. So the police officer should say, you have the right to remain silent. Please know that anything you say can and will be used against you in a court of law. You have the right to an attorney. So if you're sitting there, you're in custody, they're interrogating you, and you're answering questions, but then all of a sudden you're like, wait a minute, I want an attorney. They have to stop questioning you. They have to stop. And you have a right to an attorney. Either I want to call my attorney, I want an attorney, public defender, whatever. I have the right to an attorney. I want to evoke my right to an attorney. So they have to stop questioning you. They also have to say, okay, you have the right to remain silent. Anything you say can and will be used against you in the court of law. You have the right to an attorney. The next thing is you have the right to an attorney. And if you can't afford an attorney will be appointed you by the court. So what they do when you go to your first appearance or whatever it may be, they're going to go over with you. Okay, are you going to hire your own attorney? Well, I don't make enough money. I'm unemployed, or I only make $300 a week. What the court will do is have you fill out what we call a criminal indigent form. And you have to fill out what your income is, any assets. Like if you have, well, I only make $300 a week, but you got 1.2 million in the bank, you're not indigent. But if you fill it all out with zeros and everything, then they're going to qualify you for a public defender, and a public defender will be appointed to you. So those are 4 out of the 5. So number 1, you have the right to remain silent. Boom. Anything you do say can and will be used against you in the court of law. You have the right to an attorney. If you cannot afford an attorney will be appointed to you. And like I said, if you're in the middle of an interrogation and you're answering questions, okay, well, my name is Laura Sterling. Where do you live? Well, I live at such and such, Blueberry Lane in Blueberry, Orlando, Florida. And did you kill Johnny? Boop, I'm done answering questions. You can stop. You can stop at any time. Just because you've started doesn't mean that you have to continue on. Oh, well, I started answering their questions, so I thought I had to. I thought I had to answer all of their questions. No, you can stop at any time. This is what I get a lot from my criminal clients. God bless them. They say, well, and I'm looking at the police report, and in the police report, it talks about how the police officer read them their Miranda rights. And after they were read their Miranda rights, they were asked if they waived their Miranda rights. And they waived their Miranda rights. Now, sometimes the police will have you sign something that you've waived it because, there could be conflict there about whether or not they said it. Sometimes they'll have you sign. And so then all of a sudden I read, and my client I call it vomiting of the mouth, just everything, telling them everything. I'm like, oh my gosh. I said, why did you say all this to the police officer without first consulting with an attorney? And this is what I always get. Well, I thought I had to because otherwise I would be arrested. And I'm like, but you were arrested and here you are in front of me. So that didn't work out too well. You don't have to answer questions. You have the right to remain silent. You have the right to an attorney. If you can't afford one can be appointed to you. And you have the right to stop questioning at any time, because understand, anything you say can and will be used against you in the court of law. So that's what a Miranda. Hey, Paula, how are you? Nice smiley face. I'm so glad to see you, and I'm glad you joined me on my criminal procedures. So Anyway, so those are your Mirandas. Very prominent, there. I mean, still on the books from years ago, Miranda versus State of Arizona, where this Miranda rights came about. So if you wonder where Miranda came from, they didn't just pull it out of a hat. Miranda was actually the person that brought this case forward. So Miranda is a very, very famous individual to bring about the rights of individuals that are in custody and the rights of individuals that are being interrogated here in the US. And it was funny because I'm sorry, again, I'm hooked on things. Prime Video had this thing about what is it called? Something about murder at first sight. And it talks about these murders throughout the world. And they were in England and a murder had occurred and they had the suspect interrogating the suspect. Now in England, apparently they don't have these Mirandas. But what the woman was saying was you have to, as a police officer, ask every question you want to ask of the suspect, even if the suspect does this the entire time. They have a right to remain silent. They have a right not to answer the question. But she said, as an officer in England, you have to ask the question because it could be used against the officer in court by saying the suspect can say, the officer never asked me that question, so that's why I never answered it. And so I was like, wow, that's crazy. So the officer has to go through all these questions and ask them, and the suspect does this. Could be a very long interview. But here in the US, you're able to say, I'm not answering any of your questions, none whatsoever. We can stop this now. I'm 30 seconds in, I'm done. I want an attorney. Boop. And that's it. They cannot keep questioning you. If they keep questioning you after you said, I want to evoke my Mirandas, I want to remain silent, and I want an attorney. If they keep asking you questions, again, they can't do that. That's a motion to suppress if you say something after that. So, although they'll probably argue that you did it voluntarily, but they need to stop. They have to stop. Once you say that, they're gone. That's it. So they can no longer question. Many of my criminal clients, I always tell them, don't talk to anybody. Don't talk to anybody. I've had a couple murder cases. Don't talk to anybody. I actually took one case and he wanted to turn himself in. I brought him to the police station. They took him in back. I said, you're not to question him. That's what I told the officers, just in case my client, forgot or didn't say what he was supposed to, got scared. I said, you are not to question him. So they brought me back with him. And I said, we are not being questioned. He is not answering any questions. If you have any questions, you will ask me, but he is not going to answer any questions. It's a very short interview. And then, he was booked and everything. And then I was able to leave and I instructed him, do not talk to anybody because you never know what you say potentially could be used against you. So anyway, that's a Miranda. If you want to know more about, let's say, about the details or the dicta or how the case came about, listen, I'm a big Wikipedia gal. I love my Wikipedia and I find out a lot of stuff on Wikipedia. So look it up and get familiar with it and know what your rights are. Because I do have a lot of clients that say, well, I was never read my Mirandas. Or, hey, am I able to get off? Am I able to get off? I wasn't read my Mirandas. And I will say to them, did you say anything? Did they question you? Did you respond? Did you say anything? Well, no, but I was arrested and I wasn't read my Mirandas. Well, again, if you're not read them and you don't say anything, what can you do? There's nothing there because you didn't say anything. Smart on your part, very smart on your part. So just remember that part. If you get anything from this, remain silent. Don't matter if they give you your Mirandas or not, boom, and consult with an attorney. The best thing in your state, find out what, I need an attorney. That's all I want so that you know what you're doing. Anyway, then, oh, hi, Brian. If you are charged with a crime, can an employee of the same DA's office become a witness against you and testify against you? Or would that become conflict of interest? So I guess you're talking about the state attorneys. They're named differently in different states. Like here we call them state attorneys or assistant state attorneys. There's the elected official state attorney, and then everybody underneath is the assistant state attorney. So my question would be, why are they a witness in your case? Were they a part of it? Because then it would be a conflict. Yeah, I would think of the state attorney representing you and or I'm sorry, the state attorney prosecuting, maybe they'd have to get a special sometimes what they do is they get a special prosecutor, maybe from a different county. Like I live here in Seminole County, and maybe if that prosecutor was somehow had a conflict with me, maybe being a witness, because as an attorney, we can't really be your attorney and your witness or even prosecuting the case. That could be a conflict. So maybe they'll get a state attorney to prosecute from Orange County, bring them into Seminole County to prosecute because the Seminole County state attorney has a conflict. So be interesting to hear what you have to say or where you got that question from, because that's a pretty intriguing question, a pretty sharp one, Brian. So thank you for asking that question. That's a thought-provoking one. So I tell you guys are, I think sometimes you're smarter than me. Well, yeah, most of the time I do know people are smart. So, but you guys come up with pretty thought-provoking questions. Okay, the next one I want to talk about is here in Florida, we have levels of crimes, which every state does. It just depends on what they name them. Here we have misdemeanor, felonies, and capital cases. So, misdemeanors are the lower crimes. They're the baby crimes, I call them. They're the no, driving without a license, potentially driving with a suspended license, but that can be habitualized into a felony. Um, a battery domestic violence is if it's your first charge. Let me think of what else. Petty theft, a theft is something under $300, those kind of things. And generally, those are served if you have time to serve in jail, not in prison. Here in Florida, serving in jail is less than 1 year. If you have less than 1 year or less, you can serve it in the jail. If you have 1 year plus 1 day, they're going to send you off to prison. So that's the difference between the two there. Now we have two levels of misdemeanors, which it's funny because the levels of misdemeanors go up, they count up, where the felonies count down. Let me explain to you what that means. We have, excuse me, a first degree misdemeanor. First degree misdemeanor is punishable by 1 year in jail and $1,000 fine. Then we go up to a second degree misdemeanor. Now, you would think that that would be worse, right? Because you're counting up. But no, a second degree misdemeanor is actually a lower offense. So that would be 60 days in jail and a $500 fine. So you go misdemeanor 1 year in jail. So it would be jail, not prison, and a $1,000 fine. So a little lower is a second degree misdemeanor, 60 days in jail, and a $500 fine. So those are misdemeanors. Those, again, are, like I said, driving without a license, those kind of things. Now, knowing that some of these misdemeanors can turn into felonies if you get too many of them, such as driving on a suspended license. Generally, they'll let you get two, and they can, what they call an HTO, habitual traffic offender, they can bump you up to a felony. Now, that's not a mandatory, that's discretionary by the state attorney, but they can bump you up. So anytime I get somebody with a suspended sentence or a suspended driver's license, I tell them, listen, this is what could happen. You could be habitualized. You need to do something about your driver's license. Sometimes I talk to the state and I say, listen, it's our first one. Can we amend it down to a no valid driver's license or a failure to display? Trying to get the best for my clients so that they don't get that charge. But sometimes I just can't help it, or we go to trial and then, they lose and then they get jail time. And so I really have my clients make those decisions for themselves. So those are misdemeanors. So then we turn to the biggies, the felonies and the capital crimes. The felonies, they count down. Misdemeanors count up, one being the worst, two being the less restrictive. Felonies, they go down. So you start from the third degree felony, which is the lowest. Third degree felony is punishable by 5 years in prison and a $5,000 fine. So that's prison time. That's not jail time. Jail time with misdemeanors, prison with felonies. Then you have the second degree felony. I almost want to say second degree misdemeanor. No. Second degree felony, which is punishable by 15 up to. Now, when I say these, I mean up to. That does not mean that you're, oh, automatically 5 years, automatically 15. No, up to, up to. Anything beyond that would be an illegal sentence. The judge could not, in a first degree felony, could not charge you with 10 years in prison. They can't do that with a third degree felony. That's an illegal sentence because the highest you can go is 5 years. So the second degree is 15 years and $10,000 fine, and then the first degree felony. That's not even the highest. That's the highest as far as felony, right? As far as labeling them 3, 2, 1. So a first degree felony is punishable by up to 30 years in prison and a $10,000 fine. So you go from 5 years to 15 to 30. So then we move into what I call PBLs, punishable by life. And understand again, we're here in the state of Florida. I don't know what the other states do, but here I call it a PBL, punishable by life. Well, I don't just call it that. The state of Florida calls it that. Punishable by life means a crime that's punishable by life, just like that. And here in Florida, life is life. We have no parole. We have no getting out for good behavior. When you're sentenced to life, you are going in for life. And so, that's hard to kind of swallow at times. And so a life felony means you're going in for life. Now, the worst of the worst of the crimes that are punishable is a capital offense. We all know what capital means. Well, no, I should say we don't. But capital offenses are things like murder, first degree murder. First degree murder here in the state of Florida and in law schools, we learn in law school, is with intent, even if for a slight moment you had that intent. So it doesn't mean that you have to be like, okay, I've been thinking about it for 3 days. You can think about it for 1 minute. You have that intent. It's capital murder. And so that would mean capital means death penalty is on the table. Either life without parole, we don't have parole, and the death penalty. Here in the state of Florida, we have the death penalty. Not all states in the United States have the death penalty, but we do here in Florida. And they just signed into law. The legislator made it now. It used to be, I think it was 8-4 before. Then it became unanimous because the jury has to give their recommendation of either life in prison or the death penalty. And so it used to be unanimous. It had to be unanimous that everybody had to agree. But after the Parkland shooter and when he pled guilty and the jury could not come up with a unanimous decision on the death penalty, then that's when the legislature went into gear. And now it's back to 8-4, meaning 8 for the death penalty and 4 can be against, and that person can get the death penalty. So that's a capital case. So generally that's first degree murder intent. We also have, that was just recently signed into law as well here in the state of Florida, capital sexual batteries. Now, we've always had capital sexual batteries, and they were a PBL. What's a PBL again? Punishable by life. But now the law says if you commit capital sexual battery, which is, and let me define it for you, it's not a pleasant definition, but it's when somebody over the age of 18, an adult, we call it sexual battery. We don't call it rape here in the state of Florida. We call it sexual battery. Commits sexual battery, meaning, how do I say this? Penetration, sexual penetration, having sex, intercourse with a child under the age of 12, that is a capital sexual battery. It used to be a PBL, punishable by life, which it still is, but now what has been signed into law is also the death penalty can be on the table. Now, whether or not I agree with that, I'm sure you guys don't care, but I don't really agree with that. I think punishable by life is enough, and capital cases should be dealing with murders and deaths, but we shall see how that pans out. I'm sure there will be some, what do I want to say, some appeals or some issues in regards to that change in the law. So, again, we're dealing with first degree misdemeanor, second degree misdemeanor. Then we got felonies, third degree felony, second degree felony, first degree felony, life felonies, and then capital. Capital always meaning that that death penalty comes into play. So remember those. Those are what you need to remember. Oh, hi, Mark. I'm sorry. I wasn't even paying attention to you. How are you doing, Mark? Oh, I like that picture. Is that you eating? I'm jealous. I'm facing a dilemma where a woman shattered the window of my trailer. Oh, I'm sorry. And her partner tried to hit me with his motorcycle. Oh my gosh, I hope you're okay. However, because they were the first to contact the police, the officers accused me of being the aggressor. What do you recommend? Well, whatever state you're in, if you're here in Florida, we'd be more than happy to help you. If you're not, you may want to contact a criminal defense attorney in your area. I'm assuming if they accused you of trying to hit them with your motorcycle, there's some kind of criminal case going on there, or maybe they're just questioning you. Remember, we have this tendency, Mark, to want to we want to tell our story. You know, with anything, I'm a big storyteller. I will start from birth to the end, right? In fact, today I was at a breakfast, a marketing breakfast, and I was trying to say something, and one of the guys goes, "Land the plane, Laura, land the plane." I kind of laughed at that. I thought that was funny. Land the plane, get it down. There's no need to tell your story. There's no need. The only person you need to tell your story to is your lawyer. That's it. Don't feel the necessity to try to defend yourself with the police or defend yourself with anybody. You need to get your attorney. So I would recommend to, if you're here in Florida, I'd be more than happy to help you, Mark. If you're not, get with a criminal defense attorney in your area so you can discuss the legalities of your situation. If you've been arrested, if they're just questioning you, that's a lot of times too. They do that kind of investigation part. Still, I actually had a client one time that he was being accused of sexual battery on a child. And he was a teenager at the time too, but he was older. So they were looking into that. And they said to me that, and I told my client, don't say anything. Don't say anything. I'll call the police officer and see what's going on. So I did. And I don't say much to the police as well. And he said, the police officer said to me, well, apparently there were text messages back and forth. Could you get us your client's text messages? I said, let me talk to my client. So I'm telling my client all about this. And then I'm like, you know what? If there are text messages going back and forth, why does my client have to produce them? Don't you have a victim that has them as well? I mean, last time I checked on my phone, if I text somebody, it goes on their phone, right? If they text me, it's still on their phone, but I get it. So I wasn't really, I was like, yeah, no, I'm not going to provide any text messages for my client, whatever you feel necessary you want to do. And then I always have clients say, but if you don't talk to the police, I'm going to get arrested. Well, but if they're going to arrest you, they're going to arrest you. So very good question, Mark. I'm sorry you're going through that. I hope you do get help. Again, if it's here in Florida, I'm more than happy to help you. If it's in a different state, please see an attorney so you make sure you're taken care of. So thank you. I appreciate the call and I hope everything, or the question, and I hope everything goes well. Let me take one little drink because I'm talking a lot. Now, the last thing I want to kind of talk about, and I breached this in one of my videos, it's very confusing to people, and sometimes it's confusing to me too. A waiver of speedy trial. What the heck is that? Like, I just had to have a waiver of speedy trial signed by one of my federal criminal clients. He's in custody. I sent one of my attorneys up there to have him sign the waiver of speedy. What is that? What? That everybody was speeding? No, it has nothing to do with that. When you're arrested and when you're charged, you have a certain amount of days to go to trial. Meaning, okay, if it's a misdemeanor, you have 90 days to go to trial. So 90 days from either when you're charged with it, meaning, arrested or filing of the information or the indictment, whatever, you have 90 days to go to trial. Now, a lot of times I waive that. I waive that because I need more time. I need more time to get the discovery. We call it discovery here in Florida, the evidence, to get the evidence, to go over with my client, to go over all the options, everything. 90 days can be quick. that's too quick. When it's a felony, it's 175 days. And again, you can waive that. Generally, what we do in court, I mean, a lot of the state courts, you can do it orally. As an attorney, I can say, I've filed a motion to continue or request a continuance, Your Honor, with a waiver of speedy trial. And could we have a 2-month continuance or a 1-month continuance? And then we have to give the reason to the judge as to why we want the continuance. Well, Your Honor, this is a felony case. I want to do a deposition. I want to question the witnesses, which I've done many times. I want to do a deposition. I want to prepare for trial. I want to review the evidence, whatever it may be. Or maybe me and the state attorney are trying to come to an agreement on how best to deal with this case. So as long as the judge feels it's legally sufficient and it hasn't been waived 500 times before, because remember, the judges still want to keep track of these cases and they don't want you to go on and on and on. Now, if it's a huge case and involves multiple parties and death and all, then yeah, potentially it's going to take a little bit for it to get to trial, and people get kind of frustrated with the criminal system, because it can take a while to get to trial. But again, it's as a criminal defense attorney trying to prepare the best case for my client. And I always tell my clients, it's the state's job to prove your guilt, not ours to prove your innocence. Hi, Emily. First, I'd like to say thank you for the informative show. Oh, you're welcome. Second, is it reasonable to request a speedy trial on an unfair charge of criminal damage to property when the charge is holding the individual back from seeking employment? The case was last year in September. I'm assuming that's maybe when the person was arrested in 2022 September, which resulted in an arrest, okay? And the plaintiff refuses to pursue the charges. Well, when you say plaintiff, because in a criminal case, there is the state of Florida. That's who's prosecuting the case. And the defendant, that's the person who is arrested or charged by information or indictment. Indictment is a grand jury. So a plaintiff, there is no plaintiff involved in a criminal case. You may be talking maybe the victim, the alleged victim who's maybe not wanting to go forward. Then what I would do if you were here in Florida, and I'm just guessing that's what you're asking, because I know it's hard to get a lot of information into the questions. But, the court at some point is going to go to the state attorney and go, what are we doing? What are we doing here? What's the problem? What's going on? Or if the victim is not participating or that, what you can do is when you can file a demand for speedy trial. I want to go to trial. Now, I've done that once. I've only done one time. Have I drafted a demand for a speedy? And there's a couple rules that have to happen with that demand for speedy. Once I file it, no more than 5 days after I file it, there has to be a hearing. Meaning the judge calls you in, calls the defense counsel in with the defendant, calls the state attorney in and says, okay, are we ready for trial? I have a demand for speedy because within 10 days of that hearing, there needs to be a trial because I've now demanded speedy. The one case I did it in, their star witness, as we like to say, was being held in a different county on a gun charge. So I was like, yeah, this is the time to do it because, he's got this charge. He's being held on, is the state going to bring him down? And I did a demand for speedy. And I think I did it like on a Wednesday, Thursday, Friday, Saturday, Sunday, Monday. Yeah, I think I did it on a Wednesday afternoon. And the judge called up, okay, we're having a speedy, which was a bad time to do it. And I'll tell you why. But the judges J, okay, everybody's got to come in on Friday. And I was like, I hate to tell you, I had a funeral that I was going to out of state that weekend. So I was hoping the judge would put it on Monday. And the lovely Judge Lester, he put it on Monday. So that was fabulous. So I was able to show up on Monday and it got resolved. My client ended up playing out, but I did that demand. And it's risky because the state could have said, I'll bring that guy down to testify. Or they could have said, our witness isn't available in 10 days. We're going to null pros. We call it null pros, which is a Latin term of nulla prosecution, meaning we're going to drop the case. Or they could have just said, well, we're going to bring him on down on a goodness, well, we're going to have him transported down here to testify. So it's kind of risky unless you know, or you just want to, you're ready, you're set, you're going. But generally, when you're ready, set to go, you can do that at a docket sounding, and then they schedule you for a trial so you know. But if you're in Florida, I'd be more than happy to talk to you, Emily. If not, please, please, please talk. If you have an attorney or that person has an attorney, to have them talk to their attorney about, okay, what's going on? Because you're right, that arrest will show up on your record until such time as it's disposed of or whatever. And you're exactly right when they do a background check on you, because, right, the World Wide Web is easy nowadays. Type my name in, stuff pops up. I typed the other day somebody's name in, and something very strange popped up. And I go, why would this pop up? And I clicked on it and I went, oh, wow. So you can find anything out about anybody. So your future employer can do a background check on you. That pops up, boop, you're gone. So yeah, I would try to take care of it, especially if you're saying it was September of 2022. That's something that needs to be taken care of. And here in the state of Florida, well, it depends on the amount, but criminal damage to property, depending on the amount, can either be a misdemeanor or a felony. So you want to get that taken care of. And if it is eventually dropped, you could look into the state, whatever state you live in, of getting it sealed or expunged, where it's off your record, where that employer, unless you're working for the government, they can see it. But if you're going to work at Target, they can't pull it up. Or if you're going to work at Walmart, they can't see it if it's either sealed or expunged. So very good question, Emily. I hope everything works out. Please, if you're in the state of Florida, I'd be happy to talk to you, or whoever this person is. If you're not, please go out and seek legal counsel so that you can get those questions answered, because that needs to kind of be taken care of. But anyway, so that is a waiver of speedy trial. So a waiver and then a demand for speedy. They're two different things. So like I said, I've only done one demand in my life. It was actually pretty educational. I actually enjoy doing criminal law. I enjoy learning about the intricacies. I enjoy just dealing with those kind of issues. In fact, this morning, like I said, I was at a marketing breakfast after the one guy told me to land my plane, but they were asking me questions about being a criminal defense attorney. And they were, well, what if you know the person's guilty, or what if they admit to? It doesn't, everybody has a right to legal representation, no matter what. Everybody has a right to effective legal counsel. So that's how I look at it. I will defend anybody. Everybody's right to, that the knowledge of an attorney on their side. Hey, Ava, nice picture. Where are you? Oh, that looks like a nice picture. Thank you for this streaming. Oh, you're welcome. I do have a question regarding juvenile arrest. Oh, this is a good one. And speedy trial. Is it a specific time frame after they commit a crime that they should be seen or have their case set for trial? Is it the juvenile's responsibility to pursue the right to a speedy trial, or that of the defense to educate the juvenile on their right? Well, even as a juvenile, you have the right to an attorney. I haven't done a juvenile criminal case in quite some time. I used to, here in Seminole County, I used to be court appointed. So I'd be court appointed and I get these juvenile, the juvenile, we call it juvenile delinquencies. I would get them juvenile cases and I would represent them. So it's been a very long time. So, but I remember those days. I did kind of the goal in juvenile court is to rehab, to give them an opportunity. The goal in adult court is to punish. So, that juvenile should have an attorney appointed to them or have a private attorney. And it's really our job as an attorney to educate our clients on, what the options are, what's out there, to answer questions, to be that legal mind, because not everybody went to law school. Although I get a lot of, my friend said, is your friend an attorney? I can't answer that question. But they should go to their attorney, and that's the information that they should be getting from their attorney. I don't always know the questions that the person needs to ask me. I'll tell them everything I can. And I ask, do you have any other questions? A lot of times they talk to their friends and then they come at me with questions, which is fine. I enjoy that. I like to clear those things up for them. But really, the juvenile, it's especially different dealing with a juvenile than an adult. An adult may have more information in their head, where a juvenile, they may not. So they may not know all that, but hopefully it would be their attorney that would educate them. And again, they either have an attorney appointed to them or they hire a private attorney. So, very good question, Ava. Ava, if you're in Florida, please, we're here for you, to help you with anything, answer any questions. If you're not, and this juvenile has an attorney, it's best to talk to this attorney to get as much information from them as you can. And with a juvenile, especially, a lot of times juveniles don't know the questions to ask, and maybe their parents are good to ask those questions. Now, I always tell my clients when they bring a juvenile in front of me, maybe it's mom and dad, and this juvenile has been charged with, yeah, petty theft. They stole, I don't know, a pen or a couple pens from a Walmart. I'm just saying that would be a misdemeanor because obviously, hopefully, these two pens are less than $300, but you never know. And so that's a misdemeanor. And so, I always go to my parents. I understand you're going to be paying the bill because obviously this juvenile can't, but please understand this juvenile, this child, because you're a child until you reach the age of 18, is my client. So whatever happens, I need to discuss with my client. And anytime I have a client who's maybe incarcerated or something, and the family's calling me and they want all these questions answered, I always say, I need to talk to my client to make sure it's okay to talk to you because otherwise I can't talk to you because my client is the individual who I'm hired to represent. So even though cousin Judy or Uncle Sam or somebody may be paying that bill, my client is still the individual who I represent, and I have to ask them for clearance. And I have had clients in the past that were incarcerated that said, no, I don't want you to tell my family anything. Tell them very little. And so I do that. Sometimes I get family members that are upset with me because of that, but that's my client's wishes. That's what I have to go by. So, anyway, like I said, I do enjoy doing criminal law. I enjoy all your questions. I think they're very thought provoking. Criminal cases and criminal procedure is very specific to the state and can be very specific to the crime and what you're being charged with. I mean, I've gotten people I got an individual who was looking at life, a PBL, punishable by life, and I got him 5 years. And so what the state attorney had to do was there was a capital sexual battery he was being charged with, and then some other charges that didn't rise to the level of that capital sexual battery. So in getting him that 5 years, because capital is either PBL, punishable by life, or death, which death penalty at the time was not an option, but punishable by life. So if he gets 5 years, that's an illegal sentence. So they can't keep that. Hold on. They can't keep that charge on there. So they had to null pros, dismiss the capital sexual battery, and stick with the other one so that they could fit that 5 years into there. So I was very proud of that case, but let me tell you, that took a lot of work. A lot of work. And understand that too, your criminal defense attorney. This is not something that goes quick. I have clients that come to me and say, oh, I want this taken care of immediately. I want this taken care of immediately. No, no, no. Not when it comes to criminal cases. You don't want me to rush this through because when you rush things, you may miss something. You may miss something. I want to go through it methodical so that I can make sure that I get everything. We see what they have. We can discuss it, all of that. Because like I said, sometimes you rush, then you're going to miss things. So it's a matter of taking a breath. And I always calm my clients down and I try to talk them through things. And I really do enjoy, like I said, doing the criminal law. And I enjoy my clients, my criminal clients. I do. Some of them have gotten into situations that they just couldn't help. Maybe they were in a bad situation at the time or in a bad environment, or they just did something that they didn't realize what the consequences were. So that's what I'm here to do, is to represent them and give them the proper representation. I hope this was beneficial for you. I know the holidays are coming up. There's Thanksgiving, there's Christmas, there's New Year's. Please, please, please be careful, be happy, be healthy. Try not to get into any trouble. Try to walk away from situations. Try not to drink and drive. There's Uber, there's Lyft, there's all kinds of things. So please pay attention. But if something does happen to you and you need help, please, 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 that's what I'm here for. And you're living in the state of Florida, please give my office a call. We're going to be open. The only days I think we're closed is Christmas Day and New Year's Day. I think that's it. Otherwise, we're running through. So we're here for you. We're here to help you. We're here to walk you through what's best for you. And please give us a call. Watch my videos, continue to watch my videos on Facebook and YouTube. I'm also now have a podcast on Spotify. I also have on Facebook my blogs. I'm just going all out here. I'm getting with the young people. That's what I'm doing. So an old lady trying to blog, right? I want a piece of paper and pen. Can I not just tape it on the computer? But anyway, please be happy and healthy. I will see you in December, and I'm going to have more criminal information for the month of December. So I'll see you in December. If you're in the United States, have a happy, healthy, and fulfilling and loving Thanksgiving. Thank you so much for listening.